Okay, we're recording. It's 9 o'clock on Thursday, June 20th. We're here for a regularly scheduled meeting of the Baltimore County Board of Appeals. We're here for a public deliberation in the matter of William and Theresa Tunney. This is an appeal of a citation number CC 2307872. And in a nutshell, what occurred is that the county issued a citation, that citation number, to the Tunneys, who are the legal owners of 717 Rockaway Beach Avenue in Essex, 21221. And the gist of the citation was that the Tunneys had planted shrubbery and otherwise engaged in landscaping that impeded the water view of the adjoining neighbors. And this was in violation of, the citation alleged that this was in violation of this board's prior ruling in a related case in which we held that a 1 or 1.5 foot deck was unpermitted because it impeded the water view. This is based on a 2006 zoning commissioner hearing, I believe is the date. Anyway, the administrative law judge, Maureen Murphy, at the citation hearing recently ruled that our decision had nothing to do with landscaping, and therefore she dismissed the citation without ruling on the merits. That is, whether the landscaping in question did in fact impede the water view, and whether her ruling was that landscaping wasn't embraced in our decision. We had a public deliberation on an original appeal that was filed by, well, actually, it wasn't filed. No one filed an appeal. What happened was that the neighbors, the Rockaway Beach Improvement Association, and the individuals noted an appeal of Judge Murphy's decision, and we dismissed that appeal because under our view at the time, the witnesses to a citation case lacked the authority to note an appeal in a citation case. That could only be done either by the named violator or by the county, and since neither the named violator nor the county had filed an appeal, there was no basis, we had no authority to entertain the appeal. So that is the background. And so following the issuance of that opinion by us, which I believe was April 24th, 2024, the individuals who had filed the appeal, that is the Siegmunds, the McDonoughs, Kevin McDonough, and the Rockaway Beach Improvement Association, filed a motion to reconsider. And I take it that the basis of that, well, the basis of that motion is that we didn't address, I guess, the specific legal arguments that I'm going to call them witnesses, that the witnesses had raised trying to stand in the position of an appellant. The issues raised by them and People's Counsel. So we are here to address the merits of appellant's motion for reconsideration. And with me today is Fred Lauer and Michael Stelmach. Three of us heard the original appeal here. And we ruled unanimously that the Board of Appeals lacked the authority to entertain an appeal filed by witnesses, since witnesses are not authorized to note such an appeal. Of course, I, for one, lamented the fact that the county had not noted an appeal. If the county had noted an appeal and simply stepped back and let the witnesses handle it as they did before the administrative law judge, we would be in a far different posture. We could have dealt with the merits and decided one way or another how that the question of whether landscaping is embraced within our prior ruling. We could decide that question, but the county didn't file that appeal. And of course, the Tunneys didn't file an appeal. There was no reason for them to do so. So we are here today to consider this on reconsideration. And you know, my own view is that as frustrating as this whole matter is, in fact, the witnesses have no authority to note an appeal. They cite the general authorizing statute by which individuals can take appeals to the Board of Appeals, and they say that this overarching statute gives authority to the Board of Appeals to hear such a case. And the simple fact of the matter is that there are two provisions at issue here regarding boards of appeal authority. The first is the general authorizing statute, and the second is the specific and particular statute regarding appeals from citation cases. And where there are two provisions, the specific takes precedence over the general, and in this instance, the specific statute permits only appeals by the county or by the named identified violator. So the general overarching statute actually has no sway with us. So that's point number one, at least in my view. Point number two is that the witnesses should be able to intervene, not just intervene, but take the place of the county as the appealing party, and thereby they get around what would appear to be a statutory impediment by essentially becoming the county, putting on the county's hat and taking over as if they are the county. And they, you know, this is an unusual proposition, and they cite one case in which Judge Daniels from the Baltimore Circuit Court permitted witnesses to intervene in a zoning matter that was in front of him. And Judge Daniels was a very good judge. I have immense respect for his general view of things and his general competence, extreme competence on the bench. The problem for the witnesses here for Rockaway Beach is that Judge Daniels' opinion in that case really has nothing to do with this case. That was a case in which Judge Daniels, citing the importance of citizen participation in zoning matters, permitted the witnesses to intervene, but they were not asking to be, nor were they given the authority to be substituted for the actual parties to the case. They were permitted to intervene, and that was fine, but they didn't take over the role of the actual parties. Number one, and number two, what one could argue, I'm not crazy about this, but one could argue that given what Judge Daniels did in the case, which is he permitted the individuals to intervene and then ruled against them. thereby essentially ending the case. One could argue that his decision lacks a certain oomph, I guess, if that's the right legal term, but it's a little bit, it might be conceivably viewed as something of an empty gesture. I don't view it that way. I think it stands on its own. I think I understand his logic. I didn't go into the weeds on his logic, but he's probably right because he was mostly right on things that he ruled on. But that case simply doesn't provide the authority in this instance, in my estimation, to permit the Rockaway Beach people to essentially become the alter ego of Baltimore County for the purposes of the statute that permits Baltimore County to note an appeal. So, as frustrating as it must be for Mr. McDonough and the Sigmunds and the McDonough's parents and the entire Rockaway Beach Improvement Association, and as cumbersome as it will undoubtedly be for them to file yet one more petition for special hearing and to have a hearing in front of an administrative law judge, and then possibly having another opinion, having another hearing in front of the Board of Appeals, all of which will take years. I sympathize that they, took this matter to the county initially because they thought that would expedite an ultimate resolution, and it turns out that not only doesn't it expedite it, it prolongs it. But simple fact remains that the Board of Appeals is obliged, in my estimation, to abide by the law. We do that no matter which way the chips fall, and no matter which way and even though it might be more convenient for us to entertain this, although I'm not sure that's true, but in any event, the bottom line is, from my estimation, and I invite my colleagues to weigh in on this, but in my estimation, there's no basis in law for us to permit this appeal to go forward in the citation case, that we have no authority to permit the witnesses essentially to become the party to the case, and that the motion for reconsideration has to be denied for the reasons that I said. So that's my view. And I'm sorry to have monopolized the first 10 minutes of this, but I did want to at least get that out there, particularly since I was the one who was most vociferous in my criticism of the magistrate, criticism of the administrative law judge, and in fact, in my disappointment that the county couldn't even note a simple appeal and stand back and let the matter proceed. They didn't even have to do any work. We could have just said, hey, we note an appeal, and then gone and had a cup of coffee. But the county didn't do that, and the administrative law judge's opinion on the citation stands, and that is the end of that as far as I can see. I see no legal basis for us to alter anything that we have done or to do anything differently, and therefore I would deny the motion for reconsideration. So that's my view. Anyone want to chime in? Mr. Lauer, Mr. Stelmach?
First of all, I apologize that I can't be on the Zoom thing there. Technical difficulties, but I couldn't agree with you anymore, Mr. Chairman. I had the same view as you, I think, of Judge Daniels himself and also of his opinion. I just don't see that we can allow this, them to kind of step in the shoes, if you will, of the county, as you said. So I would also deny this motion to reconsider. Hello?
Mr.
Yeah.
Scott,
Thanks.
do you have anything to say?
You really hit on most of the things that I had intended to say, but if you'll indulge me, let me just go through this real quick. You know, I do agree with you. I think it's tempting when someone offers you the chance to grab authority or jurisdiction that you don't have, but you know, we're bound by the law and we have to abide by that. So I would agree with you. I think that I think it's possible the appellants, as you said, may think that we did not consider the issues in particular that they discussed in their motion. I don't think that's the case. Just we might not have chosen to discuss them in the opinion, but I don't think we gave them short shrift. We really did look over these things when we considered the issue. With respect to the motion itself, I mean, first of all, I think that there's an issue of failure to raise their allegation of mistake, fraud, or irregular reconsideration. I think that's required. But setting that aside, the statutes that the appellants bring up are really about the authorizing statute of the Board of Appeals, and that doesn't give us jurisdictions. I mean, I think the implication of what they're arguing is that, you know, we could pluck any zoning issue that we disagree with from the ALJ on our own and have a hearing about it. I just don't think that's how it works. I think the means of these statutes taken together are hearings. You know, every county has to have a Board of Appeals, and here is the structure of how the Board of Appeals works. And the county council has organized that structure into the one that we use. And I echo what both of you gentlemen say about the Conaway case. I mean, I think it's persuasive, but it's not binding precedent on us as a circuit court opinion. And also, as you said, I mean, I think the similarly situated party in that case was not the only appellant. I think there was another party who appealed and was also running with the case, and that's not the case here. So I would agree with both of you and deny the motion for reconsideration.
All right. Well, yeah, the question of mistake, fraud, or
Irregularity, I guess.
that whole notion, that whole set of principles applies only if you're the party. It doesn't make you a party. It can't make you a party when you're not a party. It's not. So it lets a party deal with with what would seem to be a final judgment after the final judgment within a certain amount of time, but it doesn't confer any authority on a party that wouldn't otherwise have. So it's kind of a non-sequitur.
Well, I guess in the context, what I mean is it's not meant to be a second bite of the apple.
Yeah.
It's meant to, if there are certain grounds for the reconsideration,
Right.
they have to be alleged within the context of mistake, fraud, irregularity, or whatever.
Right.
Is it?
Okay. Well, anyone have anything further to say?
I don't. Thank you, Mr. Chairman.
I think we've addressed the motion for reconsideration. I think we have a consensus here that it should be denied and without dissent. And with that, I will adjourn this public deliberation. Is that acceptable with everyone?
Yes, that's fine. Thank you again.
Thank you all. Appreciate it.